Second Circuit certified 3 questions to the New York State Court of Appeals, which is the highest court in New York State. Those 3 questions were intended to get at whether New York State's human rights law, which prohibits discrimination on the basis of criminal conviction history, how that applies in a case that they are looking at. So the first question that they asked is whether this law applies only to employers or whether it applies to any person. The court looked at both the human rights law and Article 23A of the New York Correction Law, which is a law that governs how employers and public agencies may consider criminal convictions in hiring. In doing so, the New York Court of Appeals found that only employers are directly covered under the limitation under the New York State human rights law. The second question certified to the Court of Appeals was whether the New York State human rights law applies to direct employers or indirect employers. The Court of Appeals found that there's no actual definition of employer for this section of the human rights law. So they looked at the common law, which finds that you have to use a 4-factor test to determine whether an entity is considered an individual's employer for the purposes of criminal conviction discrimination. There are 2 important holdings for out-of-state employers from this case. First, out-of-state entities, whether they're an employer or a contractor, may be held liable under the aiding and abetting provision of the New York State human rights law. These entities may also be considered joint employers under the New York State common law by following the 4-factor test. Employers and contracting entities outside of New York should be mindful that they may be held liable under the New York State laws.